Today we're considering a piece of legislation and several nominations. Before we turn to that, I've got a few words about the retiring of Justice Kennedy. It's been 30 years now, and for those 30 years, he's served the country well. His confirmation was 97-0. Obviously, I was one of those who voted for him. He's been one of the most influential justices of our time. His opinions will continue to be studied by law students, cited by attorneys, and relied upon by judges for generations to come. If I were to pick one area of the law where Justice Kennedy had his most significant impact, it would be First Amendment. Justice Kennedy had a deep reverence for liberties guaranteed by that amendment, writing or joining the majority in cases protecting the freedom of speech and religions. He wrote the majority opinion in Citizens United, holding that the government can't prevent corporations, unions, and nonprofits from engaging in political activity and particularly when it's political speech. That's speech that is at the heart of the First Amendment. Justice Kennedy joined a majority opinion, Hobby Lobby, agreeing that the government may not force institutions with sincere religious objections to subsidize contraception coverage for their employees. He was also recently joining the majority opinion in Masterpiece Cake Shop, which was decided by a 7-2 vote. The court held that Colorado could not single out an individual for punishment based upon religious beliefs. And just this week, Justice Kennedy shot down another state law abridging free speech by rejecting the argument that pro-life pregnancy centers should be required to advertise where women could obtain government-funded abortions. Of course, we could go on describing a lot of Justice Kennedy's contributions to the law in other areas, but just to summarize, his commitment to federalism, protecting our Second Amendment rights, and recognizing the constitutionality of the tradition of legislative prayer. I expect the president will send us his nominee to fill this seat in the near future. When, haven't heard any specific date. Once we receive the nomination, I'll look forward to holding the hearing in the upcoming weeks. I expect that we'll follow the same approximate schedule as we have in the past several Supreme Court nominations, even going back a long time before I was chairman. Regarding the schedule, the minority leader suggested that the Senate not hold a hearing this year because it's an election year, claiming that was the majority's position in 2016. So I would clarify his total, if not intentional, misunderstanding of the Biden rule. As I'm sure most of you recall, in 1992, then Senator Biden urged the Senate not to consider any potential Supreme Court nomination that year because it would be dropping a nominee into what Biden said, quote, the cauldron in the middle of a presidential election year, end of quote. So we followed the Biden rule in 2016 to not hold a hearing for a Supreme Court nominee in the midst of a presidential election year, but that doesn't include every election year. Senator Schumer seemed to be suggesting that the Senate couldn't hold a hearing for a Supreme Court justice every other year, which of course is a preposterous suggestion, quite contrary to Justice Kagan's hearing and confirmation in 2010 in the midst of a midterm election. We will be holding a hearing in the upcoming months on the president's nominee this year. Now to today's agenda. We will not be able to vote on 2 nominees for the appellate court, even though they're ready for votes. So Britt Grant, 11th Circuit, David Porter, 3rd Circuit, will be held over for another week. We will, however, vote on several nominees today, including Andrew Brasher for the Middle District, Alabama. He has served as Alabama's Solicitor General. In this capacity, he has argued in front of the Supreme Court 3 times and has filed a number of briefs to the court. As Solicitor General, he represents the interests of his client, the state of Alabama, and does so faithfully, whether he agrees with every position his client takes. So take that into consideration when we vote on him. It's clear from his hearings and from his written responses that Mr. Brasher understands the different role a judge plays as contrasted with his current role as an advocate on behalf of his client. In fact, he acknowledged that as a judge, he will, quote, faithfully apply all Supreme Court precedent, end quote. I'm confident that he will do so. I'm also confident that if Mr. Brasher is confirmed, the parties who come before him will get a fair shake, regardless of who they are. I won't hold against him any of the positions his state has taken, and I'll be voting for him. We also have on the agenda the Music Modernization Act. I'm a co-sponsor with Senator Hatch, and that's Senator Hatch's bill. Music copyright and licensing laws have been criticized for being too difficult to comply with and for not adequately rewarding musical creativity. This bill would improve the current music licensing framework and reward the professionals who create American music. The Music Modernization Act would set up a mechanical licensing collective for all digital music so that streaming entities can more efficiently find and compensate artists for their work. The bill includes the Classics Act, which would add copyright protection for pre-1972 sound recordings, and the AMP Act, a bill sponsored by me and Senator Feinstein, which would allow for the payment of performance royalties to producers, mixers, and sound engineers of sound recordings, which are pretty much a major part of the ingenuity that comes through these pieces. The Music Modernization Act enjoys broad stakeholder support. In fact, the House version of this bill passed unanimously 415-0. We also have on the agenda for the first time the Anti-Terrorism Clarification Act. This bipartisan bill will be held over at the request of our ranking member. The Kiwi Act will be held over again for 1 week while the bill's sponsors continue to resolve outstanding issues. Finally, I want to address the issue of family separation. As my colleagues are aware, on Tuesday evening, the U.S. District Court for Southern District of California issued a nationwide preliminary injunction. I know Senators Tillis and Cruz are working in good faith with the ranking member Feinstein and Senator Durbin on potential bipartisan compromises. I hope their discussions will produce a result that will keep families together and allow for humane detention of family units pending outcome of their cases. In order to facilitate these discussions, Ranking Member Feinstein and I have requested the Department of Homeland Security and Health and Human Services to brief all senators on this committee about the present situation and how we solve it legislatively. Their insight will be valuable and will allow us to legislate effectively and quickly on this issue. Once again, this briefing is finalized. Once this briefing is finalized, we'll be sharing more information about that now, Senator Feinstein.